Thank you all for joining today. I know it's a very busy time of year, so it's a bit of a compliment to me that you're all making time to come and listen to me talking about EIA. As you can see from the slide, this is part of the National Planning Hub Environmental Impact Assessment Training Capacity Building Programme. Going to talk a little bit more about that in a couple of slides' time. This is the second webinar. A recording of the first is available, and you'll find that and all sorts of other information on the website, which I will mention in a minute. The third webinar is scheduled for Thursday, the 29th of January. Details of that are going to be circulated this afternoon, and you'll also find details on the website. So encourage you to look out for that and join that event. In terms of quick agenda for today, doing a bit of an introduction, then going to spend I think it's about 40 minutes doing the introduction to key legal issues. Inevitably in that time, it is going to be quite a high-level introduction, but that was very much the point. EIA can get quite complicated and scary as a result, so we were keen to do an introduction at a fairly high level because that actually helps demystify it a bit. Yes, there's lots of detail to catch up on, but if you at least understand the general principles, the general approaches, that gives you a really good starting point on it. So that was very much the idea of Josh Fothergill's first webinar and also this one, when I'm looking a bit more particularly on the legal issues. And there will be a live Q&A session at the end, and I'll tell you about that in a minute. And we'll be closing at 11:30. This is just a bit of an introduction to the actual programme. Very understandable why the Improvement Service, the Planning Hub, decided to look at environmental impact assessment. As I said, it can get quite complicated, it can get quite scary, but it is quite a key part of a lot of planning and other consent applications. So very important for us to have that focus on it. As the slide sets out, program started last month, runs until March, and includes a baseline survey, a series of online workshops, case studies, and the like. And you can see there's a summary there about what was involved in the early stage, November, December, and then what's happening Q1 next year. And just for those of you who are maybe not so familiar, National Planning Hub, based in, led by Scottish Government, working in partnership with the Improvement Service. It's building on the earlier hydrogen and housing hubs, and it's tasked to provide direct support to planning authorities to accelerate decision-making and development delivery. And in terms of this particular programme in EIA, Fothergill Training and Consulting Limited, working with Brodie's, have been commissioned by the Improvement Service to deliver an EIA capacity building training programme as part of the National Planning Hub. As I mentioned, if you look at the National Planning Hub, there are various web pages around EIA, lots of information, more of it being rolled out. So definitely worth a look. On housekeeping, and I can see someone was already mentioning some difficulties. Pretty familiar territory on webinars. You're off mic and you're off camera, so don't worry, we're not going to hear you or see what you're doing. This is being recorded, and as I mentioned, will be put on the web page with the slides. We will exclude the Q&A, so don't feel that your Q&A will be going public. And what I always say to my colleagues, no question is too silly, because quite often people will start and say, this is probably a silly question, and it turns out it's not. So please feel free to use that session at the end to ask anything about EIA that's come up through the presentation that you maybe didn't quite understand. If you use the Q&A function for that, so if you look on my screen, it's at the top, might be at the bottom of yours, but there's a chat feature. If you use that, if you've got any technical problems, and next to it, there's a Q&A feature. And if you use that to type in any questions, you can type those as we go through. I'll not answer them until the end, but please, on the way through, if there's anything, just shove them on. It's easier sometimes than wait until the end and you've maybe forgotten them by then. So that was the introduction. Now on to the actual content. As I said, very much an introduction, quite broad brush, high level, general, focusing from a legal perspective, understandably, given that I'm a lawyer and that's where my interest lies. In terms of the learning objectives for today, to give you a core understanding of the role of environmental information in deciding planning applications, the key legal rules and definitions, and then a bit of a discussion about reducing the risk of legal challenge, because that's always a bit of a concern, understandably, in everyone's minds. So hopefully you'll all get the song reference here. The point is, it's just to remind you that as a planning officer, you're quite often dealing with policy matters. And I'm going to touch on that in a moment. The important thing is the law is something that you must follow. Policy is more flexible. And that's why the song reference works. The law will always win in the sense that the law is a requirement. You must follow it. It is mandatory. The reason, though, why we have so many court cases is quite often the law is not clear. So saying the law will always win does presuppose the kind of question around, yes, but what is the law? And in part, that's something that I'll be mentioning on the way through. So as I set out before, the first thing is just looking at the role of environmental information in deciding planning applications. This is a bit of contextualizing. The planning officers will be well familiar with this. Section 25 in the Scottish Act, it's the same provision in the English Act, different section number, and we can all kind of quote this from memory. Determination should be made in accordance with the plan unless material considerations indicate otherwise. So what the courts have set out is a process. First question, does the application accord with the development plan? Second question, what are the material considerations? And then you balance up the material considerations in the development plan. That's what we're all familiar with. So you may be thinking, well, why are you mentioning that? We're talking about EIA. The point is, well, how do the environmental effects fit into all of that? Broadly speaking, two ways. Um, they're relevant to compliance or otherwise with development plan policies, and they're also relevant to material considerations if they're not issues raised by development plan policies. So rhetorical question here, and it's just making the point, even if EIA is not required, planning permission can be refused on grounds of environmental impact. Environmental impact is always going to be relevant to planning decisions. So the excitement around is it EIA development or isn't it is almost a distraction, because the same information can and should be taken into account even if it's not EIA development. It's just maybe not going into in as much depth or in such a rigorous manner. But I think it's a point that a lot of the members of the public don't really appreciate. They somehow feel if the planning authority decides a project's not EIA development, then it's completely and utterly downgraded. And yes, the procedure is different, but really the environmental effects are still very relevant. I've included this because all of that kind of then poses the question, well, what's the point of EIA? And it feels a bit weird, um, given that I've just sketched out a program for you, a 3-month program looking at EIA, to be saying, well, what's the point of EIA? But just picking up on what I was saying, this quote, I think, captures it quite well, and it's the Scottish Government circular. I've noted it on the slide. And it's really just saying, it's drawing the information together in a systematic way, helping to ensure that the predicted effects, scope for reducing them, are properly understood. So it's just introducing a more systematic approach and a bit more rigor around that, because developments which fall within the definition of EIA development are considered to be important enough that they should be looked at just in that more focused way. So there is very much a point to EIA. And in terms of how all of this impacts on the decision-making process, it is very much an impact on the process. I've called it an enhanced process to make the point that there's more procedure involved. So the legal rules that I'm discussing today largely focus on the process, not the outcome. And the second bullet point explains what I mean by that. The environmental information is taken into account. It plays a key role, but the ultimate decision on the application isn't necessarily taken on the grounds of environmental impact. So to give an example, I've picked this one just because it is so well known. The Trump International Golf Course up in Aberdeenshire, checkered planning history. That's not particularly relevant, but the relevance is the quote on the slide. It was granted on the basis of economic and social advantages, justifying the adverse environmental consequences. So it's very much an example of the balancing process within planning. An adverse environmental impact might lead to a refusal, but there might be other material considerations which justify an approval. And that was what happened for the Trump International Golf Course development, those economic and social advantages. So again, it's making the point that EIA is part of the process, but doesn't necessarily determine the outcome. Moving then to look at key legal rules and definitions. The starting point is the definition of EIA development, because that determines the projects that the enhanced procedure applies to. And what the regulations say is, if it is EIA development, planning permission cannot be granted until EIA has been carried out and environmental information taken into account. So it's very much at the start identifying, does EIA apply? If it does, it has to be done, and the information that's produced through that EIA has to be taken into account in the decision. The important thing being taken into account, again, just emphasizing it's not necessarily determinative of the actual decision. So the key definition there is EIA development, and this is what we refer to as screening. There's two main parts to EIA. Well, I suppose you could really say there's three, because there's reporting at the end. But the initial ones, the screening procedure, which decides is EIA required, and then there's the scoping procedure, which looks at which topic areas need to be part of that environmental impact assessment, depending on the characteristics of the project. So key definition there, EIA development. One of the issues that comes up is what we refer to as project slicing or salami slicing. The point here is the courts have identified that it would be wrong to allow a project to be consented in stages if that was used as a device to avoid EIA. So if the project as a whole would require EIA, it would be wrong to allow it to be sliced up into several sections to avoid that. And the example, it was a motorway in Spain, and quite literally, they decided to do the motorway in several stages, each of which would not have required EIA in its own regard. But the court looked at it and said, well, no, the motorway as a whole is the project, not the individual parts of it. Inevitably, that's a rule that has caused difficulties, and I'm now just reminding myself where I've got to in the presentation, and just seeing if I'm going to come back to that in a moment. Yes, I'm going to come back to that in a moment. So, question on the screen there, when is EIA screening needed? And this is one of these situations where it's quite complicated to explain, but actually it's a bit easier when you have an actual proposal in front of you. So the starting point is, for what we refer to as Schedule 1 developments, EIA is mandatory. So that's quite easy in one sense. You look at Schedule 1, if the project falls within those categories, you've got to do EIA. That is quite an unusual situation. Those are the kind of mega developments that don't come up all that often. It's much more normal for there to be a situation where the planning authority needs to screen on a case-by-case basis, and that's for the developments that fall within Schedule 2, which predictably we call Schedule 2 developments. And in those situations, the planning authority have to produce a screening opinion if the proposal is listed within Schedule 2 and is either at or above one of the relevant thresholds or is within a sensitive area. So Schedule 2 sets out thresholds, and there's also a list of sensitive areas. So again, just, I suppose, to reassure you, this feels complicated, but when you actually sit with the proposal and look at Schedule 1 and look at Schedule 2, it's a bit more straightforward than it seems. Not without difficulties along the way. And that was one of the things that I wanted to just touch on. Within Schedule 2, there can be problems around interpretation. And I've given the example there about urban development areas, urban development projects, it not being clear precisely what those could include. But we just have to take the words and apply them because those are the words that are used. And I've mentioned there about the risks of project slicing. And the next slide just summarises the key principles around that from the court decisions. Unfortunately, today there wasn't enough time to go into those court decisions, but what I'm going to do is do a short article mentioning the key court decisions, and that will get put on the website. So if you look out for that, there's a bit more explanation to come. The key principles the courts have identified. Development should not be considered in isolation if in reality it is an integral part of an inevitably more substantial development. It's very legalistic language, that, but you can hopefully see it's that integral kind of element. And the thing that the second bullet point is reminding us, it is inevitably very fact specific, and it would be a mistake to rely too heavily on particular circumstances in an individual court decision. For instance, one of them was about a bridge, which was kind of christened the bridge to nowhere. And that was one where, because of the individual circumstances, the court said that was part of the housing development, not a project in its own right. But subsequent to that, there was a different bridge somewhere else, and the court looked at that and said it was a project in its own right. So that kind of illustrates the difficulty of looking too closely at the circumstances in the court decisions, and it's the key principle test in the first bullet point, which is the important one, just about being an integral part of a wider development, a more substantial development. And the cases that I'll mention in the note that I'll put on the website explain that in a bit more detail. Right. Continuing along on the key definitions, EIA report, we used to refer to an environmental statement, or ES, and I think that is still actually the language in England. But what we have is an EIA report or an EIAR, and that is the output of the environmental impact assessment. The assessment obviously is a process. The report then reports on the findings of that process. Associated with that is the procedure that's called scoping, and that's sitting looking at the potential impacts of the project and agreeing which of those should be part of the EIA. And an example of an awkward one is socioeconomic impact, where there's certain aspects of the regulations do indicate that's relevant, but for a lot of projects, it is felt that it's not a significant enough impact for a particular project to justify it being part of the EIA. Again, doesn't mean it's irrelevant to the planning decision. It just means that the socioeconomic information, if it's not in the EIA, becomes part of the planning application. So the procedure is just slightly different, but the information is still relevant. So that's an illustration of the type of considerations that apply at the scoping stage. And one of the things within EIA that is talked about a lot is the need for proportional EIA. And it's a concern that it all just takes too long. There's way too much information. The EIAR is way too long. And effective scoping at the beginning of the process certainly assists proportionate EIA by really looking and saying, are there things that we don't necessarily need to include within the EIA? So if you hear people talking about proportionate EIA, that's a key part of that discussion. And then just continuing to follow through on the legal rules. Regulations say the EIA report, if there is a scoping report or direction, the EIA report must be consistent with that. So if the developer has obtained a scoping report from the planning authority, they must make sure that everything that says should be done is actually done within the EIA process and then reported on in the report. So that, again, just helps you understand how all of this flows through. And right. The EIA report itself, EIAR, Regulation 5 sets out what it's to contain. And this is very much at a minimum. Descriptions of the development, its likely significant effects on the environment, features measures to avoid, prevent, or reduce likely significant adverse effects, in other words, mitigation, and reasonable alternatives studied by the developer. There is a non-technical summary, NTS, and that's very much a nod to the fact that members of the public will be interested. So there should be a non-technical explanation before it gets into the more technical stuff. Any other information specified in Schedule 4, and then a statement of relevant expertise and qualifications of experts. That was something that was introduced as a enhancement of the procedure. So you will see within EIARs just an explanation of how incredibly qualified and experienced everyone is that's involved in that process. So that gives you an outline of what's included within the EIAR. Those of you who have used them before will know sometimes they can be incredibly long documents, lots of technical appendices. There's different styles and approaches, but that's very much the sort of baseline, as it were, of what it should contain. Now, just to finish off, and if you just give me a minute, I'm checking my timings to see how well I'm doing here. I'm doing all right. Good. Looking at the legal challenge point, there's a lot of litigation in England and Wales around EIA. It's an easy target for objectors. Less so in Scotland, but then that's partly because we just have less litigation. But just to touch on some of the issues, the screening and scoping stages. So again, just to remind you, screening is the EIA development, scoping, what should be included in the EIAR. Those processes largely involve an exercise of professional judgment. And that is very much an area where the courts very consistently, north and south of the border, have indicated they do not intervene on matters of judgment unless they're perverse or irrational. And I've just given you a quick example there, a local one Glasgow Council, Wynford Estate and Mary Hill. The issue there was the demolition of 4 tower blocks, approximately 600 flats, and the council, through screening, deciding it was not EIA development. That was controversial. There was a lot of litigation, but ultimately the court agreed that Glasgow Council had exercised appropriate professional judgment in deciding it was not EIA development. So it's quite an interesting example because I think we all would tend to think demolishing 600 flats, that's quite a big project. That sounds like the kind of thing that should be EIA development. So it's an important reminder that EIA isn't really about quantity. It's not about the size and scale of the development as such. Some of the thresholds bring that in as a factor. What we're looking at is the environmental impact, the potential environmental impact. So some quite large scale developments do not require EIA. But the point that I'm making on the slide, a lot of EIA decisions involve professional judgment. So the risk of the court saying you got it wrong is quite low, providing obviously you follow the legal principles that I've been mentioning. I mentioned project slicing. That's what I'll put details of some of the relevant court decisions on the website. This concept of functional interdependence, from those court decisions, it's clear it's hard to prove that there has been project slicing, that the particular project shouldn't be considered in isolation from a wider project. So again, it's a favourite point of attack for objectors to a planning application, but it's actually a hard case to win in court, which doesn't necessarily stop them challenging it, of course. A few thoughts about reducing the risk of legal challenge. I've said reducing the risk. In some ways, if an objector is not happy with the decision, they'll challenge it, they'll find something. So it's not possible to exclude the risk, but you can certainly make it much harder. Check the law and procedures and follow them. So as I said, today is very much a general introduction. I've not told you about the detail of the procedures. If you are going to be involved in screening, scoping, etc., then you do need to sit and make sure you know what the procedures are. Ideally, by looking at the regulations, the Scottish Government circular that I mentioned earlier on, noted on the slide, is a good introduction to the regulations. The court decisions also illustrate application of the rules within the regulations. The second point there, be clear about when a rule must be followed and when the rule allows you to apply professional judgment. So if part of the regulations says you must do something, you must do something. But for something that it gives you some amount of discretion, professional judgment, then, as I said, that's going to make it much harder for anyone to challenge in the courts. And in terms of writing up any reports, decisions, it's much better if you use the correct legal terminology. If someone thinks you've misunderstood something because you haven't used the right terminology, that might encourage them to challenge it. The courts aren't particularly harsh in these situations. They accept that you've got to look at, for instance, a report as a whole rather than cherry picking sentences or phrases. But just making sure you use the correct legal terminology will make it harder for someone to claim that you've misunderstood things. So it's hopefully just a kind of easy win, as it were, avoiding future pain. And giving clear reasons, that always makes a big difference. It doesn't necessarily need to be very lengthy reasons. Again, the courts are reasonably sympathetic in those situations, but if they're not clear, that's where you get into problems. So that was just some thoughts around what you can do to hopefully avoid a legal challenge, but certainly if you're not avoiding it, making it less painful, or making sure that it focuses on a few narrow points rather than there being a lot of mudslinging of various things, which, with the benefit of hindsight, you think, oh, I could maybe have done that a bit better. That's been quite a quick gallop through. And this is just a reminder. I've provided an introduction to how environmental information is used in deciding planning applications, and particularly the point that it's used whether or not it's an EIA development. Procedure is different, but the information is still relevant. Touched on key legal rules and definitions, and also just given you some thoughts around reducing the risk of legal challenge. So I've got some comments just in finishing it up, but I'll just say at the moment, this is the time to start thinking about any questions you might want to put in the Q&A, because we will have 10 or 15 minutes, probably actually 15 minutes, so plenty time if you've got any questions. Just while you're thinking about that and maybe starting typing them, going back to the programme, it's very much capacity building around EIA. The next steps to look out for Q1 next year, as I mentioned already, the seminar, the next webinar on Thursday, 29th January, the details of that will be going live today, and emails will be going out. Information will be available on the website. So recommend that to you. And as the slide mentions, there will be further webinars. Well, that's the royal we. Josh Fothergill mainly is looking at the information which he's gathered through various stakeholder discussions to inform the content of those webinars. So we'll be looking to make sure that it covers very much the key things around EIA, but picking up on what the actual needs are, rather than us thinking that we know what you need. So it's very much trying to design in the feedback that he's been getting. And again, just to remind you, if you check the web pages regularly, because there will be material going up from time to time. So there will be new content. So do keep an eye on that and do use that content.